You're listening to Dare to Think, the official podcast of MereLiberty.com. I'm your host, Carrie Baldwin, and in today's episode, I'm speaking today with Gary Chartier about the concept of law in an anarchist society. To most people, anarchy is a term associated with an absence of law and order. But for philosophical anarchists, anarchy is about a stateless legal order. That is, civil governance without a single entity in control of the creation and enforcement of law. It's true that some self-described anarchists are merely political agitators. But you may be surprised to know that there are a growing number of legal and economic scholars who have arrived at the conclusion that the greatest threat to real civil governance is the state itself, and that we should be pursuing a polycentric legal order. And Gary is here to explain what that looks like. Join me, Carrie Baldwin, with Gary Chartier as we dare to think about anarchy and legal order. Gary is an American legal scholar and philosopher. He's currently Distinguished Professor of Law and Business Ethics and Associate Dean of the Tom and Vi Sapara School of Business at La Sierra University in Riverside, California. Gary, I'd like to start off by hearing from you how you came to embrace philosophical anarchism.
Wow. I guess there are longer and shorter versions of that story. I think I discovered, in a serious way, libertarian ideas in late adolescence. And I think I was probably a fairly typical adolescent libertarian in that I programmed computers, I read science fiction, and I didn't have social skills. And also probably not atypically, I had parents who were Goldwater Republicans and probably passed on some ideas to me, some instincts to me. I ended up taking quite a long detour through a fairly sort of boring kind of mainstream social democratic kind of stance. But even in that period, in the course of writing my doctoral dissertation, I was exposed to what certainly seemed like very good arguments undermining state claims to authority. I'd probably run across those at some points earlier as well. And then I just kind of parked all of that. And really, I would say that George W. Bush and Barack Obama radicalized me and pushed me over the edge into anarchism. And I kind of revisited ideas that I hadn't thought about for a while. And when I discovered the work of the market anarchists like Roderick Long and Sheldon Richman and Kevin Carson, their work really gave me a way of integrating what I would say would be kind of lefty concerns that I had embraced over the years with the libertarian instincts that I think, probably still had. So I guess that's the short version.
So I do think it's safe to say that most of the people in my audience are going to see themselves as either, favoring limited government or minarchism and or capitalism. And so I think it'll be helpful to define a couple of terms before we begin, so that everybody can hear we're on the same page. So I'm going to give you a term, and I want you to first tell me what you don't mean by it, and then tell me what you do mean by it. So the first term, of course, is anarchy.
Yeah. So by anarchy, I mean the absence of rulers, and I take it a ruler to be, in the narrow sense, someone who imposes his or her will by physical force. And more broadly, I suppose one can talk about various kinds of social pressure that aren't physically violent but are still problematic as things to which anarchists would object. But the sort of core meaning, it seems to me, is the rejection of the kind of ruler who claims to run a state.
Right. Okay. And then what about capitalism and anti-capitalism?
Yeah. Fighting over those terms, I think, is a mug's game, and not something I'm terribly invested in. I've written stuff about anti-capitalism, but that's not a hill I want to die on. So, there are probably 5 different definitions of capitalism that people find themselves operating with, and the problem, I think, is that those definitions are often in tension with each other. As Roderick Long has suggested, capitalism is really a kind of anti-concept because it tends to mean something for many people like the free market system we have now. And
Mhm.
it seems fairly clear that what we have isn't anything like a free market. And so you can either mean by capitalism, then, if you want a conceptually coherent notion, you can either mean a free market or the system we have now, but you can't mean both at the same time. But that is, it seems to me, precisely what people tend to mean. So I'm inclined to want to avoid the term. When I talk about anti-capitalism, I guess I would say I'm talking about opposition to the kind of state-corporate alliance that does seem to be very much a feature of economic and political life today, and has been, has been for a while.
Got it. Okay. And then in your book, Anarchy and Legal Order, you talk about socialism. So how do you define that?
Yeah, so obviously, if socialism means something like, enforced collective ownership or state control of the means of production, I have no sympathy for that. But I think that with other individualist anarchists rooted in the 19th century, work of people like Benjamin Tucker, I am sympathetic to Tucker's attempt to talk about, himself and his compadres as part of the socialist tradition. And what they seem to have meant by that was broadly responding to the social question in a constructive way, where the social question, I guess, meant for them primarily issues related to conflicts between labor and capital, but probably also dealt with a range of other sort of broadly social issues. So I'm sympathetic to trying to sort of revive the Tucker era understanding of the socialist tradition. That's certainly not, in the obvious sense, Marxist, certainly not statist, certainly not collectivist. Again, because I recognize that, especially for friends who have roots, let's say, in Eastern Europe, the language of socialism is unavoidably associated with pretty bad stuff. That's certainly not a hill I want to die on either, but I think it's at any rate worth remembering that the term for people who were recognizably libertarian meant something else in the past, and perhaps there's some value in keeping that in mind.
In your book, Anarchy and Legal Order, you argue from the foundation of a contemporary version of natural law. And I think most of the people listening to this know that natural law theory was first articulated by Thomas Aquinas. Um, so, what is the contemporary version of it? And why do you think it's the foundation for anarchist legal order?
Yeah, so natural law theory has roots very, very deep in Western thought. So, Aquinas certainly is going to be the single best known natural law theorist, but probably you can go back to people like the Stoics and Cicero and find views that are kind of recognizably natural law views. And Aquinas's own views are certainly deeply rooted in those of Aristotle. So I guess I articulated in Anarchy and Legal Order, I articulated a view of anarchism and anarchist legal order in natural law terms because I'm a natural law theorist, right? Not that I started out with anarchism and then asked how could I, articulate that best. How about natural law theory? Rather, I have both anarchist sympathies and natural law sympathies, and what I wanted to do in this book was to figure out a way to weave them together. The kind of standard natural law view certainly of Aquinas, and indeed of most contemporary natural law thinkers, tends to be communitarian and conservative. It certainly is not an anarchist view, but on the other hand, I think it's got the potential to be viewed that way. So the theoretical position is a contemporary version, I should say, because while all natural law theories, I think, at least in the tradition that I'm interested in, are concerned with human flourishing and what makes for a good life, and see the question of ethics as beginning with the question, what does a good life look like? A contemporary natural law theory of the kind I've worked with here, the so-called new classical natural law theory associated with people like Germain Grisey and John Finnis, has really sought to articulate a natural law view in terms of post-World War II analytic moral philosophy. And that's a matter probably both of assumptions that are made. For instance, the recognition that straightforwardly descriptive claims can't logically entail normative claims, and so you've got to get at the normative in some other way. And just, I think, the way in which the vocabulary that's employed and the sort of techniques of clarification and so forth that are characteristic. So that's why it's contemporary. But really, ultimately, what we're talking about is a view that's deeply rooted in, over 2 millennia of Western history, and that places the question of flourishing front and center, and asks with an eye to flourishing, what makes for a good life? And my answer is, a good life is a life with others, a life in society. Humans are necessarily social creatures, but they are not necessarily, for that reason, subjects of states. A good life need not be, and there are certainly, I think, good reasons definitely for it not to be, life under the rule of a territorial monopolist.
Right. Okay. So, and I know Murray Rothbard also works from natural law theory. So, are you generally in agreement with his take on it, or?
So Rothbard's Ethics of Liberty was one of the first libertarian books that I read when I was first discovering libertarianism as an adolescent. And I think there's a great deal to learn from Rothbard. My own natural law approach isn't Rothbard's. I mean, I think, this is a big family tree with lots of different branches. And,
right.
I've been very attracted for decades to this particular version that I like very much, this new classical natural law view. And, Rothbard was associated with, I think, some other strands of the natural law tradition. So, I certainly think that I've learned a lot from Rothbard, and I think others can learn a lot from Rothbard. But the approach that I've taken isn't, in various ways, just the same as his.
I think we've laid a pretty good foundation. So I want to paint a picture of what polycentric legal order looks like. So in common parlance, when we talk about government, we're talking about it in terms of the state, that entity that has a monopoly on civil governance. And then we also talk about it in terms of civil governance itself. So can you just sort of paint a general picture of how polycentric legal order works in a practical sense?
Sure. So I start out by articulating an understanding of what an appropriate framework for the substance of law ought to look like. And I try to defend that in terms of, an understanding of the importance of a particular conception of property, which we can get back to later if you like, and certainly it concerns with other kinds of elements of what we might think of as a protected sphere for personal choice. And on the basis of that groundwork, then, I argue against the appropriateness of a of a territorial monopolist, a kind of conventional state, basically for three reasons. First of all, I think states are illegitimate because they disregard the consent of those they claim to rule. They're also dangerous because they engage in all kinds of predatory behavior. And I think they're unnecessary because social order can be maintained without them. And so that's a kind of broad framework that I lay out. And then I suggest that what that means is that if there shouldn't be a monopolist, then the services that a legal system ought to be understood to provide, namely, on the one hand, primarily dispute resolution, and then provision of, the protection of safety and the provision of remedies for various kinds of injuries and so forth, that there's no reason why those services have to be provided by territorial monopolists, and that instead we can imagine a range of overlapping social networks in any given geographic area in which different networks provide people with these services, and then interact with each other as kind of long-term players, and therefore maintain a certain level of peaceable agreement, just as states do. So you might imagine in the same area, people choosing to resolve legal disputes courtesy of a rabbinic legal system and Catholic canon law and 5 different dispute resolution providers of a very kind of stripped down secular variety, and all of these with clients or members, as the case may be. Some of them would be more commercial, some probably would be non-commercial, and so forth, in the same geographic space and able to interact with each other because they and the networks they're part of have every reason to want to maintain long-term peaceable relationships and therefore figure out how to resolve intra-system disputes with each other. So that's the broad kind of model I guess I'd have in mind.
Okay, so I'm going to play devil's advocate just a little bit here. And let's say that you have a dispute between somebody who holds a more Catholic view and somebody who holds, say, a rabbinic view, and there's some conflict there. So, how do you resolve that?
Yeah, so I have a conflict with you. You're affiliated with the rabbinic legal system. I'm affiliated, let's say, with the Catholic legal system. And, we can come up with different things, but perhaps it's a contract dispute of some kind. We've got different rules in some cases. Now, obviously, we first of all have to recognize that the needs of people in the same social environment will be such that there are going to be pressures toward a certain amount of standardization across, different networks. And so it would be unlikely that there would be wildly different views, right?
Mm-hmm.
My legal system says that 2 people can make contracts. Your legal system says people will be shot if they make contracts. I mean, that's, fairly
Yeah.
But let's just suppose there is some significant difference here. Then what I think we have to imagine is that, so we think about what happens in the United States. Let's say if you have a lawsuit between people who are citizens of different states, or what happens internationally if you have legal disputes involving people who are citizens of different states in the in the international sense.
Mm-hmm.
And what happens in each case is that there are choice of venue and choice of law rules that kick in. And of course, they won't necessarily be the same. Maybe we're going to conduct our dispute in California, but the legal rules will be those of Montana, or whatever.
Mm-hmm.
And we clearly have exhibited the ability to sort that kind of thing out. And so my assumption would be that just as geographically based legal systems can work that kind of thing out, there's no reason that non-geographic, non-territorial legal systems can't do the same thing, that they're going to have rules that they work out with each other precisely because as I suggested earlier, they're repeat players and they
Mhm.
want to be able to get along with each other and resolve disputes. Indeed, one service they need to offer their members is the ability to resolve disputes with members of other networks. And so, therefore, it's not going to be in their interest or the interest of the members to maintain some kind of bellicose posture that refuses to accept any sorts of sort of meta rules for engagement across networks. Instead, they're going to want to have those rules in place. They're going to negotiate them out with each other, and perhaps at different points renegotiate them. Though the less renegotiation, probably the better from both perspectives. And so I don't see that as a it's technically complex in somewhat the same way that
Sure.
sorting out choice of law rules when you're in Delaware and I'm in Wyoming are and we're in dispute. That can be complex, but working it out isn't terribly in principle complex. It's just a sort of logistical challenge. And the same thing again if we're you're a citizen of England and I'm a citizen of Russia. So I don't see it as meaningfully different from that. And I think there is really an incentive for different legal regimes, as I like to call them, to sort out those kinds of agreements and minimize conflict. Costs go down and benefits to members go up.
So, anarchy, the term anarchy is commonly associated with lawlessness,
Mm-hmm.
but it seems that law is still created through these legal regimes. Is and I've heard, I guess I've heard scenarios in which like if you have two dispute resolution entities come up with a solution, then that could be considered some sort of precedent that we would associate with our current conception of law. Is that how you've conceptualized it?
Yeah, so I mean, how a given sort of hierarchy of courts, either within or across judicial systems, would think about precedent. I mean, I don't think there's any kind of, sort of cosmic rule about how that might work out.
Mm-hmm.
For instance, as the great libertarian legal scholar John Hasnas has pointed out, and Todd Zywicki, I think, as well, has discussed this issue, that in early common law courts in England, precedent was far less important than it's become in later later centuries.
Mm-hmm.
This may suggest that we may sort of overvalue the desire to find precedents. On the other hand, of course, predictability matters a lot to us, and you want to know how to proceed in ways that will reduce the risk that you're going to encounter the legal system, that you're going to end up in a dispute with somebody of one kind or another. And so there is certainly some incentive for the generation of some precedents. And whether that would, how that would work out in a given legal system and across legal systems, I guess I don't have any general view of what's to be expected there, except that I think, there's a strong but hardly overwhelming impulse in favor of predictability, and precedent certainly is a way to serve that. And so I would expect that any legal system would include some concern for precedent, but I suspect that might actually be among the things that would that would vary across systems, is just how they treat precedent, and different consumers of their services might obviously have different preferences there.
Right. So I think it's probably easiest to conceptualize this legal order when we're talking about contracts, because we already have organizations in our system today that deal with third-party dispute resolution and keeping those contract disputes out of court and things like that. But what happens when you're dealing with something like violent crime? How does that get resolved in this sort of system?
Yeah. So the whole category of crime is I think a statist category, and it's a category I try to avoid if at all possible. Crime, I think, ends up being an offense against the king, and so. Or as we'll have it often in the contemporary U.S., a criminal case is said to pit somebody against, the people of the United States or the people of the state of California, which is to say nobody in particular other than particular authorities in those environments. So I want to avoid talk about crime entirely. I think the criminal law is a great source of mischief and nuisance for all kinds of reasons. And I'd rather talk in terms of tort. And, what we often have in our society, of course, is a sort of parallel set of tort actions to criminal law actions that, frequently aren't drawn on when the perception is that, criminal doesn't have deep pockets. Perhaps the only legal liability that ends up being involved is that imposed by the criminal law system. But sometimes, of course, we do have sort of parallel suits by victims or by their successors in interest. So my own view, so a little complicated, right? Because on the one hand, I think that there's no I've tried to spell out an account of what I think the law ought to be in the book. But obviously, when you've got a polycentric legal order, there's no guarantee that in any particular case, as we've been talking about already, the legal norms are going to be the same. And so I can talk about what, if when I create my dispute resolution agency, here's what we're going to do. But of course, other people have to follow along. I think one reason probably that you might see other legal regimes than mine favoring the tort model is that the criminal law right now involves attempts to do all sorts of things to people, for nonviolent conduct.
Right.
So let's say, for instance, take an obvious example. Lots of people are, end up in the custody of the justice system because of consensual activities involving chemical substances that they want voluntarily to put in their bodies or offer other people to put in their bodies.
Right.
And so this is a point that I give David Friedman credit for noting. Probably other people did, but I associate it with David's Machinery of Freedom. Once I'm actually a sort of paying customer of a dispute resolution agency, even if I have some abstract preference for, objecting to other people's ingestion of various chemicals, at some point it's going to occur to me that I'm going to pay a lot less as a customer if I'm not paying for people to go and find other people and harangue and harass and intimidate them because of their ingestion of chemicals. And so I'm really going to have to ask the question, what actually matters enough to me if I'm actually the one paying for it? If I can't sort of pass on the costs to, a couple of 100 million other people and really kind of bury the individual trivial cost to me, but instead I really get to decide what I'm interested in funding. There are probably reasons for me not to be very excited about that sort of thing. So all of this is just by way of, I guess, of background to what I'd want to say about your question, which I guess I'm building up to because it's a difficult question. I don't think I have a perfect answer to it.
Sure.
So a tort system, ultimately says, look, after the fact, ex post, when wrongdoing has occurred, what we do is to seek compensation for it of one kind or another. We seek, and so we're not interested in the tort system may have other kinds of objectives. I try to argue in the book that some of those objectives are just illegitimate, and some of them, can be welcomed as side effects, but probably don't provide independent justifications for the system. So I think, the existing criminal law, for instance, takes the goal of retribution quite seriously. I think retribution is actually a morally abhorrent notion that involves just causing harm, as if that were a good thing on its own. And deterrence doesn't, I think, for reasons I try to spell out in the book, provide any independent justification, but you can welcome deterrent effects, I think, as foreseen side effects of a tort system, right? That if people know that you have a reliable system that's going to impose liability on them, and they're going to have to accept, responsibility, and accept significant financial losses for doing things that harm others, then that is certainly going to be deterrent. It's not the only kind of deterrent in place, because the only responses we can imagine are not just the ex post ones, right? Because so one thing that it's important to recognize is that under the current state-based legal system, the police are not terribly reliable, in significant part because they don't have any particular obligation to you. And as multiple cases over time, perhaps most painfully, a case called DeShaney established. It was Wisconsin versus DeShaney, I think, in 1986. Winnebago County Social Services, maybe. Anyway, I'm forgetting the name of the full case. But in any event, this was not a police case. It was parallel. It was a social services case in which state social services agencies returned a child to a parent who so badly injured the parent that the child was permanently brain damaged and so forth. So was there any kind of legal recourse against the social services agency that had first taken the child and then returned it in this case? And the answer was no, there's no particular responsibility on the part of the state agency to any particular person. And that similar notion has played out in multiple police-related cases. By contrast, if a police agency is one element, right, of a dispute resolution service of one kind or another, so it's your client and you can fire it, it does have a particular contractual obligation to respond to your calls and to provide you with safety. And even if there are too many clients for everyone to be guarded perfectly at every time, if there's not an efficient responsiveness to client concerns, clients are going to get very unhappy very quickly. And so you can count on better ex ante defense. And while I don't believe in punitive violence, I certainly think that defensive force is appropriate. And so that the potentially violent are also going to be deterred by the recognition that their victims may be defending themselves, but also will be, I think, probably better served by defense providers. And I would expect that also to stop a lot of violent acts. You can't obviously stop all such acts, but I think that would certainly make a difference.
So it's interesting that you bring up social services, because I know that at least among a lot of the women in my audience, there would be a concern for, children in situations where they're being victimized by parents. Yes. And so, I guess my response to them has typically been, well, in this sort of situation, you would probably have social service providers, but you've got, you don't have a monopoly on it. And so there's less of a chance for corruption on that end. But their question is always, well, how do they get involved in a situation if a child's in that situation and nobody else knows about it except the parents, and the parents are, they're the ones who are causing the harm? Then how does that work out?
Well, and of course, I mean, that's a question, one would ask the same question, right, with respect to state social service agencies. If nobody knows, then, in the nature of the case, that's an issue. Now, the state agencies and of course, I presume that there are also people in your audience with horror stories about
Sure.
protective services and ways in which, really disruptive things can happen unjustifiably with respect to families. So it cuts both ways.
Yes,
And,
absolutely.
And I don't have a perfect way of drawing that balance. I suppose that, in general, CPS tends to get involved today primarily because I suppose there are probably two kinds of things or three kinds of things. Family members, report concerns, neighbors report concerns, or CPS personnel are visiting for other reasons. Social services personnel are visiting for other reasons and observe things that, that trouble them about the way children are being treated. And I presume that, so let's bracket the question, just what authority in a stateless society you might want to have someone acting as a surrogate for the child might have. That's an interesting and, question we can come back to. But however you conceive of that, whatever you want people to do, how would they get involved? Well, I think they would get involved in those same ways that we've just talked about, namely, either one parent's concerned about abusive behavior by the other parent, or, people in the environment are concerned. Or again, I think if we imagine, the equivalent in that sort of setting of churches and other nonprofits providing social services to people, obviously they're going to, in some cases, notice things that are troubling and that lead to concern. Then there's the question, obviously, of, okay, so what do you do there? Which is the same question I think we face now. And, all I can say is, I think you've got to be concerned primarily with the interests of the child, but with the recognition that those interests ordinarily include maintaining positive relationships with parents, that I think things have to be pretty bad to really try to separate those, and that you've got to have some kind of due process. But how beyond that, this is not an area in which I'm an expert, and I feel woefully ignorant.
Sure. Well, and I'm recalling Robert Higgs's statement about how we shouldn't think about an anarchist society as being utopian by any stretch of the imagination, that, we're going to have a bad situation. We're going to be dealing with, very difficult things in a polycentric legal order. But when you introduce a monopoly state, then it's much worse.
That's the thing that when there's only one option on the table, there isn't any expectation of responsiveness or flexibility. And as a result, I think you can consistently expect bad behavior from monopolists. And that's very wise and typically so.
This is the end of the first half of my interview with Gary Chartier. In the next half, Gary and I will discuss his conception of property rights, how social change might be achieved under anarchy, and Gary will bust some myths about anarchism. You've been listening to Dare to Think, the official podcast of MereLiberty.com. I'm Carrie Baldwin, and I'm an independent researcher and writer working outside academia. My mission is to challenge and rethink our paradigms for understanding society by applying Reformed theology and philosophy to politics, religion, and culture in order to encourage individual freedom and responsibility within our own spheres of influence. This episode was created due to the generous support of my patrons and underwriters. I am so very grateful to Bob, Patrick and Shannon, David and Nina, and Jean for helping me get this episode published. If you've enjoyed today's episode and would like to join me and my other patrons and underwriters in our effort, you can sign up at MereLiberty.com/membership. Joining on a monthly membership comes with exclusive rewards and premium content. Alternatively, you can choose a one-time donation. You'll find a direct link to the membership page in the description to this episode. You can listen to more episodes by subscribing on virtually any podcaster, and you can read my articles on MereLiberty.com and the Libertarian Christian Institute, where I'm a regular contributor. You can now also follow me on Facebook at facebook.com/carrie.mereliberty, and my Twitter handle is @mereliberty. Also, if you wouldn't mind rating my podcast on iTunes and leaving me a review, that really helps other people find my podcast.